Good afternoon, everyone. This is Professor Jameson. This will be the video lecture to accompany Chapter 1. Before I get into the material, I'd like to go over a couple things that might help you use these materials in the most effective manner. The first important caveat is that my video lectures and the PowerPoint are not, I repeat, not a substitute to the text. Okay? I would highly recommend that you read the text, meaning whatever particular chapter we're on, before you watch the video. And there's a very good reason to do so. One of the things you're going to be doing if you ever become a legal researcher and writer is you're going to have to learn to figure out things for yourself. Okay, and the text is going to be difficult. So what I'd recommend you do first is read the chapter. If there are things you don't understand, write things in the margin of your textbook. And then after you've read the chapter, watch the video. And if I don't resolve those issues in the video, then what I'd do if I was you is email me, and either we can set up time to chat about it, or I can respond in writing, and most of the time that resolves it, or we can Skype, whatever. But I highly recommend that you read the material. Okay, most of the quiz material is going to be directly out of the book, and so that is very important. Okay, these lectures are not required viewing, although I highly recommend that you watch them because most of the students find them extremely helpful. Okay. Accompanying this video is a PowerPoint on the first chapter. And what I recommend that you do is you open up that PowerPoint and follow along with it, because I am going to generally just follow along with the PowerPoint. In fact, I've got the PowerPoint up right now as I'm doing this particular video. Another option you can do is to actually print out the text of the PowerPoint, use it as a study guide, and as I'm doing the lecture, you can make notes on anything that I supplement the PowerPoint slides with, and that'd be a great study guide to have. Okay, so and also what you can do is, if you don't like looking at my beautiful face, you can just close the window and just watch the PowerPoint slides. And then as I move from slide to slide, just click down or click on the particular PowerPoint and move to the next one. I like to have the actual slides themselves open on the left window when I do these PowerPoint lectures, but you do whatever you want. Okay, so you can just print out the text and write things on the side, or just follow the PowerPoint, or ignore the PowerPoint and just listen to me. It's up to you. You're the students, you're the adult. It's your education. Chapter 1 is entitled Law and Sources of Law. In this particular chapter, we're going to go over the American system of law, the tripartite system of government, and sources of law. Okay, this chapter provides kind of a general overview. So if there are questions that you feel are unanswered, don't worry. We're going to be delving into this stuff in greater detail in later weeks. Okay, this is just to kind of familiarize you with some of the concepts that we'll be studying throughout the course. Okay, let's talk first about what we call our common law heritage. Okay, common law, another word for it is judge-made law. Okay, now this surprises a lot of people, but in our country, and in pretty much every country that was colonized by England, the judges are free to make up their own law. Okay. Now, it doesn't happen as much these days as it did in the past, okay, because the legislature has kind of taken over that role of making the laws. But if there is no law on a particular subject, the judges are free to make up their own. Okay. With one exception, and that is the state of Louisiana does not follow the common law system. The state of Louisiana, being as different as it is, one of my favorite states to visit, follows what they call civil law. And the way things operate in Louisiana is a little bit different, kind of in every way. We'll talk about civil law, so we have something to compare and contrast it to with the common law. Okay, so let's talk about the common law. Okay, common law emphasizes what we call case law over legislation. And with case law, what I mean is laws or cases that were decided by judges. Legislation is certainly important, and today it's even more important. Okay, but most of the law that we have in the United States today, whether it be tort law for personal injuries, or contract law, or more importantly, property law that governs real property and things like that, the laws were all invented by the judges over the centuries. And the legislature basically took those laws and those cases and the laws decided by those cases and codified them, which means they put them into a statute, which is a law that is drafted or created by the legislature. So they basically just took the law that the judges made over the century and turned them into statutes. Okay. The common law developed case by case from decisions over the centuries. And now I'm going to go into a little bit of a history lesson on how we got the common law. If you don't want to listen to that, it's totally fine. It's not going to be on the test. But it's of historical significance, and we'll give you a background of how we got to where we are. So if you don't want to listen to that, just fast forward a couple of minutes into the lecture, and you won't have to hear my boring lecture. Okay. Where do we get the common law? It came from the English. And how did the English get it? Well, we have to go back to 1066. Okay, that's why I have that picture at the top of this week's lecture. Okay, the picture's from the Bayeux Tapestry, which is a document, which is a big tapestry. It's still in England today, and it documents the Battle of Hastings. Okay, now how did the Battle of Hastings occur? I don't want to get into all the details, but there were two people who were competing or thought they had the right to the throne of England. Okay. One was a guy named Harold. Another guy was a guy named William. Okay, William, now known as the Conqueror, so I'm kind of letting you know who won the battle. He was the king of Normandy, which is the area of northwest France, and he thought he was the rightful king. So what he did is he took his army on boats over to the shore of England. He had a battle with Prince Harold, and William won. Okay. The reason that William became a king is because he won. Okay. The former king, Edward the Confessor, died without a son, and that's why there was this dispute to begin with. Okay. So now William is the king of England. Okay. William isn't English. William is a Frenchman. And he's really not even a Frenchman, because the Normans were actually Vikings that came from Scandinavia and took over northern France a few centuries before. Okay, but William's now the king, and it creates an interesting situation because William doesn't know anything about England. He doesn't even speak the language, and in fact, the nobility of England for the next 200 or 300 years doesn't even speak anything close to English. They speak French, and so what do you do when you conquer a country? Well, first thing you do is you go around and check out and see what you got. Okay. One of the reasons you have to do that is because you have to reward the nobles and the lords that fought for you in the battle, because they want some of the spoils of war. Okay. And you give them titles. Okay. Like the Duke of Marlborough and the Duke of Kent and the Earl of Oxford, whatever it might be. And with that title comes land. Okay. Because all wealth is basically tied to real property at this time. Okay, they didn't have a stock market. You had gold or you had land. So William, not necessarily William, but his predecessors, they ride around the countryside and they create this book called the Domesday Book that has every little thing that is in England. So they have an idea of what the wealth is, how to tax the people, and how to divvy out that wealth to the French lords that have conquered England. Okay. Now, the king is the ultimate power. Okay, the king, whatever the king says goes. Okay, but kings generally do not run around thinking, oh well, this is a really good law, so this is going to be the law. Okay, what do kings do? Well, they drink a lot, they eat really good food, they fool around with their mistresses, and more importantly, they try to conquer new territory. They fight battles for their glory and expansion of their kingdom. Okay, and in fact, William and the kings that came after him, remember, are ruling England and they're ruling France, and so they're trying to expand their territory in France. And in fact, the French and the English have a war called the 100 Years' War, okay, where they're fighting back and forth for control of France. Okay, so if the kings aren't making the law, who's making the law? Well, you might say Parliament, okay, which is the legislative body of England. But Parliament doesn't really come around for another 200-300 years, and they really don't have any power at that time. Okay, so where does the law come from? Well, the judges make the law. Okay, the kings generally go around appointing judges, and these judges ride around from town to town and decide cases. And this is what we call the circuit. Okay, the circuit is kind of the area where they go, because not every town necessarily had a judge. They would come to town for a week or two, or how long they needed to resolve local disputes, and then they ride on to the next town. Okay, and they were free to make up the law as they saw fit. They were the legislature. And so what would happen is about every few years, the judges would get together and they talk about the decisions that they made. And when they made these decisions, they talk, well, that's really good, that's not so good, here's some other points. And sometimes maybe one person would make a decision in one area and another judge in another area would make the exact opposite decisions. And what they eventually did is they got together and started formulating exactly what the law should be. And they started writing down these decisions that they made in books that they called reporters. Okay, and we still have reporters today. Okay, these are books that contain the decisions the judges make and the reasons for the decision. Okay, so now we have books of law that contain prior decisions that judges who face a particular controversy can look at and say, hey, you know, this judge Abernathy over here, he decided it this way, and I really liked his reasoning, and this case is pretty similar, and so I'm going to go with that. Okay, and that is the concept of what we call precedent. Okay, generally, judges do not like to upset precedent, which means if a case has already been heard on a particular set of facts, okay, they're very loath to go against what another judge has said unless they feel that decision is really badly reasoned. Okay, and closely linked to this concept of precedent is the doctrine of what we call stare decisis. And stare decisis is a Latin phrase that means it's already been decided. Okay, under the doctrine of stare decisis, and we're not going to get into this now, we'll get into it more when we talk about the court system. Basically, if a judge who's higher than you in the chain of command has already made a law that covers the case that's before you, you must follow it. Okay, so remember these two concepts. Precedent, which means judges generally follow the decisions of other judges that on similar facts that they, a case has been decided. And stare decisis, which is kind of more strict, which means that the judge must follow a decision from a judge that's higher than him in the chain of command. For example, in our system, a trial court must follow a decision from an appellate court directly above him. And all courts in America must follow a decision by the Supreme Court of the United States. Okay, so that's where our doctrine comes from, and that's how it kind of evolved, and that's the concept of stare decisis and precedent.